Today I'm going to talk about some items that people overlook or misconceptions that people have when they file bankruptcy, or common issues that we have that come up in the filing of a consumer Chapter 7 or Chapter 13. One of the most important things I can advise people is that if you have a claim against any person or an institution for whatever reason, you must list that on your bankruptcy. Your bankruptcy is sworn to under oath, and if you forget to list the fact that you have a claim against another driver for a car accident, the defense attorney for that other driver can use your omission to tell the state court judge that they're not going to pay you. Some of the claims that you might have would be auto accidents, malpractice claims such as medical malpractice, disability claims, employment discrimination claims, a contractual dispute claims, or most importantly, where people owe you money, accounts receivable. You must list all of those for both the trustee, for the purpose of the fact that you're under oath, and for the fact that to keep your claim in state court or appropriate other courts. So it's extremely important you list all claims. Some of the assets that people do not put down or have trouble with are insurance assets. Even though most people carry some form of life insurance, if it's carried through your employer, you should just make note of it. But any form of insurance should be scheduled as an asset in your bankruptcy. For example, you might have some term insurance naming your spouse or children as beneficiary. The term insurance policy has absolutely no value, but it still must be listed. You're not going to lose it. You also might have a whole life policy which has a cash surrender value. That cash surrender value is part of your exemptions. It, of course, must be listed. The other item some people overlook is inherited property. If you're entitled to an inheritance as a result of somebody passing away in your family or otherwise, the day that person passes away is the day that you're entitled to that inheritance. There's no such thing as probating for real estate. Real estate passes by operational law. So if even though a deed might be in a spouse's name or a grandfather's name, and you're inherited under the will or by state law, you're the actual owner, and that must be listed on your bankruptcy. A lot of people forget that, gee, I'm going to get this inheritance, but it hasn't been probated yet. And they don't think about putting that down on their list of schedules. It's very important you list that. Sometimes people omit the fact that they're what's called a remainder interest. For example, the family owns a piece of property, and the mother is living in the property, and she gave the property to you subject to the mother's life estate, or everybody calls it lifetime dowry or whatever, right to live there. But that remainder interest is property of the estate, and it must be scheduled. Whether it has a value or not is up to a bankruptcy trustee to determine. Many times, by the way, these items have very little value because, remember, a trustee must consider how much a willing buyer would pay to a willing seller for your remainder interest. Usually that amount is negligible. The other item which comes to mind are income tax refunds. Your right to receive a tax refund in the next year has a partial value based on when you file your bankruptcy. Generally, with the $10,000 personal property exemption, it does not become as important, but it's something we all need to calculate to make sure you'll get to keep your full income tax refund. Since the Tennessee legislature changed the exemption law, we've seen very, very, very few people have to give up their refunds in Chapter 7. Now, Chapter 13 is a little different process, because income tax refunds are considered income and generally will go to the Chapter 13 trustee, subject to some agreed exceptions. Generally, the trustee will allow you to have $500 if you're single. If it's a husband and wife, $1,000, or $1,500 if you have minor children. This assumes that your Chapter 13 plan will go for 5 years. The other items that we generally see or sometimes get questions on: do we have to list everybody? I've got my favorite doctor. My mother lent me money. You must list everybody, absolutely everybody. Remember, you're under oath. But after your Chapter 7 bankruptcy, not in Chapter 13, but in Chapter 7, you can voluntarily pay back whoever you want. If it's a family member and you might have borrowed $500, you make some earnings, you can go pay that family member back. It's perfectly legal. So these are some misconceptions that come up in usually in a Chapter 7 bankruptcy, and I think everybody needs to be aware of these common misconceptions. Thank you.